Before Rosa is made possible by the Levine Museum of the New South. And by viewers like you. Thank you.
She was a forgotten pioneer that few have ever heard of.
She really sort of drifted into relative obscurity after this.
Sarah Mae Fleming's wild ride through our nation's courts started on a bus.
Sarah Mae says she got punched in the stomach.
The lawsuit remained a family secret.
You never heard about this issue, but all of a sudden it just came about out of nowhere.
And years later, we now know what happened before another heroine's important stand.
There was someone else that encountered the same problem that Rosa Parks encountered.
It was a different time in America and a period when designated seats on public transportation vehicles determine a person's status in a very unequal society. Hello and welcome. I'm Steve Crump. The name Sarah Mae Fleming does not appear in our nation's history books, but she made a monumental contribution by helping to erase divisive barriers of the past. As a young woman, she was fearless in taking on South Carolina's establishment of that era by making an important stand against injustice. It would prove to be a bittersweet journey. While laws were changed, this courageous woman never saw any personal rewards. Her 1954 court battle came first, before the well-known efforts of Rosa Parks. Over time, Sarah Mae Fleming would fade into obscurity, and decades later, she is regarded in many of this country's civil rights circles as a forgotten pioneer. Living in South Carolina's largest city during the first half of the 20th century meant understanding one's assigned place in a very separate society.
We used to walk to school, and the black kids had to walk to school, the white kids ride buses.
I was born in 1953, when much of this was starting. And as I was growing up, you saw the signs, you heard the people talk.
In 54, you knew who everybody stood. People were, if they were racist, they were racist. You knew exactly where it was.
Columbia is the proud home of the University of South Carolina and a long-standing seat of established Southern power. Milestone moments are publicly honored in a community where historical differences remain out in the open. Clearly and boldly, the contrasting legacies are celebrated just yards apart on the grounds of the state capitol. One is a Star-Spangled Tribute trumpeting the role of the Confederacy, and another acknowledging the triumphs and strides emerging from an unfinished struggle. Engraved successes and deep sorrows imprinting the state's African American Memorial, an important monument showcasing the fight for equality. However, one individual in her very important act of bravery fails to receive any public attention. This woman's unsolicited gesture of courage, carried out from the seat of a bus, bucking legal tradition and altering changes in public transportation across the segregated South. The result left a lasting blueprint, changing transportation policy throughout the country. She was a little-known torchbearer who was just 20 years old and had only a 10th grade education. She was the granddaughter of former slaves and went by the name of Sarah Mae Fleming.
When we talk about a heroine or a hero, an unsung hero or heroine, I think that's what she is the face of that.
Without question, Rosa Parks is the much-admired matriarch of the civil rights movement who is internationally revered for refusing to give up her seat to a white rider and being arrested in Montgomery, Alabama.
It was, 17 months before Rosa Parks, this case began, and this case moved along and moved to a very surprising conclusion with the Fourth Circuit, the most conservative of the circuits, being really one of the first circuits to say that Brown versus Board means more than just no more segregation in education. It applies to other things.
None of us for one moment, criticize the public acclamation that has been bestowed upon Mrs. Parks. She is fully entitled to all of the public recognition that she's gotten. But here is the one that never got recognized nationally until quite recently.
Born in the 1930s during this country's Great Depression, Sarah Mae Fleming came along at a time when more than 80% of all African Americans across South Carolina lived in rural communities. Her relatives own land in the Richland County outskirts of Eastover, not far from Columbia. They still call it home.
What happened to her, so many people right in the community didn't even know about it.
Among the outspoken relatives keeping the story alive are her brothers, Odell on the right and Malachi on the left, as well as Sarah Mae's grandson Kenyon, who moved back to Eastover after finishing college in Rhode Island.
About it, but it was nothing that my mother or family members, nor my grandmother, ever brought up. It's never brought up around the table, Thanksgiving, Christmas. You never heard about this issue.
While farming the palmetto soil provided the family source of steady income, agriculture wasn't Sarah Mae's calling. Her livelihood came from following a similar path taken by other black women of her time. She worked as a domestic for white families in Columbia. Riding to and from work on a city bus during the 1950s meant accepting Southern society's big stick policies.
It could be empty seats on the bus, but if it's over halfway towards the front, you stand up. It could be one white person on every seat, and all the back is crowded with black.
Today, the Richland Transit Authority operates Columbia's bus system, but a half century ago, it was run by utility giant South Carolina Electric and Gas. The intersection of Main and Taylor is where a history-changing odyssey began on the 22nd day of June in 1954. It is the corner where Sarah Mae Fleming boarded a bus heading to work. After paying her fare, she stumbled into the pages of history and didn't anticipate the upheaval that would unfold that day. Witnesses say that driver Warren Christmas started off with a verbal scolding. That's when things got out of hand.
She got on the bus, and she just had come off, I think, from one job, gone to another one, and trying to get there. And she was tired, she said, and when she went to the seats, all the other seats were filled up, but this seat was empty.
She explained that the bus was very crowded, and she was standing up toward the front because there were no seats in the back. And the bus driver yelled at her to get to the back of the bus, and she had no place to move. And she said she rang the buzzer to get out at the next stop because she was feeling humiliated. And some white ladies went off the front door of the bus because they couldn't get to the back. So she attempted to follow them out, and the bus driver, her testimony was, struck her in the stomach to enforce her to go through the back and get off the back of the bus.
She came, and as far as I can remember, it's almost 50 years ago, she came and told me the bus driver hit her across her stomach and told her to get to the back.
He struck her in the stomach, with a fist. And I really believe that. No, my sister, I would have to say that's what happened.
And the fight or the little hit had to be more than what she said is, because I know Sarah, her principles was very high. Her whole attitude was she had a positive attitude. If the gentleman had to come back and just say, I'm sorry, I shouldn't have done it. But Sarah knew he was wrong.
What happened to Sarah Mae Fleming that day failed to make the evening news, but word of her humiliating experience eventually trickled to Majeska Simpkins, the legendary and well-connected secretary of the South Carolina NAACP. She found a gutsy lawyer who would take the case.
Philip Wittenberg was a young white lawyer who had not so long long before he met Sarah Mae Fleming, defended a black woman in a case that involved a city bus and segregation.
But she was very pleasant, and she always had a smile on her face when I met with her. And she understood what was going on, and she understood the problems.
Seeking claims for civil rights violations, Fleming sued South Carolina Electric and Gas for $25,000 in damages. Her case was filed in what's now the state's federal bankruptcy court.
I considered it to be my responsibility to make sure that my judge made a correct decision.
Attorney Bob Thomas was then a law clerk preparing to write a brief in this case favoring Fleming's argument. His boss was federal judge George Bell Timmerman, the father of South Carolina's governor, George Bell Timmerman Jr. Both men were avowed segregationists and made no bones about opposing integration of any kind.
He dismisses the case on a motion. There's no trial. He dismisses the case on a motion saying Brown versus Board has no impact on Plessy versus Ferguson. Plessy versus Ferguson is still good law. Segregation in railroad cars and buses and other forms of transportation is still in effect.
He wanted to make a statement. And so he wanted to grant the motion to dismiss.
Home to the Fourth Circuit Court of Appeals, Richmond, Virginia was the next place Sarah Mae sought relief. Like Columbia, it was a stronghold of the Old South, where reminders of past battles weren't easily forgotten. That's when Thurgood Marshall and lawyers with the NAACP jumped in the fray with Philip Wittenberg. Surprisingly, Judge Timmerman's earlier decision to dismiss was overruled.
We consider that a great victory that the case was still going forward.
But those judges on the Fourth Circuit had the courage to rule the right way. They had been ruling the wrong way for a long time in a lot of cases, you know. But on this one, they went the right way the very first time.
The fight proceeded next to the highest court in the land, and 10 months later, all 9 U.S. Supreme Court justices would agree with the lower court of appeals by sending a strong message. They unanimously chose not to hear the case. Sarah Mae Fleming's suit created a flurry of front-page headlines on practically every major newspaper across the country. Actions carried out by the federal courts opened doors for sweeping changes in many locales beyond Columbia.
It was a message that really was not received in South Carolina, but by the powers that be. It really, at that time, was not a significant case to the powers that be in South Carolina. It was a significant case in the sense that it was reported in the black community, and it was seen as a step along the road to victory.
Defiance in Dixie took hold not long after the High Court's decision. Reaction, swift, blunt, and forceful. With their heels deeply dug in, leaders across the South rebelled against this ruling from the federal government.
Of course, South Carolina was very much dedicated to principles of separation of the races at the time.
It was essential to them to preserve segregation for some reason, and that they were just determined.
The battle changed, but the feelings were still the same.
North Carolina's Governor Luther Hodges called the decision a further invasion of states' rights. Opposition was promised by Georgia Governor Marvin Griffin, who said the ruling would be opposed by all possible means. And that year, the South Carolina legislature held what's been titled its segregation session. And Governor George Timmerman Jr. regarded the action from the High Court as, quote, judicial dictatorship.
I think it's an important case because it's the case that actually led to the decision that was relied upon that ended the Montgomery bus boycott.
The court's action was viewed profoundly in Montgomery, once the capital of the Confederacy, a place honoring Jefferson Davis. That's where the relentless efforts of Martin Luther King Jr. and much of the African American community pressed on with their boycott, even though the bus company there offered to stop its policy of segregation. Another stumbling block was also in the way. Members of Alabama's power structure were among those emphatically ignoring the High Court's decision. And another bus boycott lasted for 6 months in Tallahassee, Florida. The change resulting from the Fleming case had fallen upon deaf ears in both cities. Meanwhile, back at the federal courthouse in Columbia, Judge Timmerman again refused to hear the case.
It ended up going to the Court of Appeals twice, U.S. Supreme Court one time.
By the time the feds once again sent the case back to the Carolinas, Sarah Mae Fleming had married John Brown from nearby Gadsden, and before the litigation was over, she wouldn't be the only victim. A hate crime often associated with white supremacy was delivered at Philip Wittenberg's front door.
I heard some racket outside, and I looked out, and there were a bunch of my neighbors standing behind a burning cross and looking at it. And so I went outside and ran them all off and kicked the thing down, and the telephone was ringing, and I came back in, and I had some threats of violence to my child and my wife and me, and if I continued on with this case.
He goes to court the next day, and nobody, he said, mentions it. Nobody mentions that there had been a cross burned on his lawn, these threats, not the judge, not the other attorneys. It was really Philip Wittenberg and Sarah Mae Fleming alone in that courtroom the next day.
And when I showed up for court that morning for the trial, I was not aware that that threat had been made. I didn't learn about that until later. But I thought it was pretty horrible.
I continued on with the trial in any event, but when it came to another appeal, my family insisted, both sides of the family insisted that I'd gone far enough and that was it.
The cross burners were never brought to justice. Attorneys Matthew Perry and his colleague Lincoln Jenkins picked up where Philip Wittenberg left off.
I remember that as my very first involvement in cases that were handled by the National Association for the Advancement of Colored People.
In this book detailing Judge Matthew Perry's career, one chapter is dedicated to the Fleming case, the passage researched and written by federal judge Cameron Curry.
It was in, I think, 1956 that the Montgomery boycott ended. And so it was that Fourth Circuit decision that had occurred back in July of 1955 that led to the decision in Ryder versus Gale and the ultimate decision in the U.S. Supreme Court that ended the boycott and ended segregation on buses.
Both Sarah Mae Fleming Brown and attorneys from South Carolina Electric and Gas squared off again in front of Judge Timmerman in the summer of 1957. Attorneys on the side of the utility company said the driver merely stuck his arm out during his scolding of Fleming to prevent her from using the front door. In her emotional testimony, she described feeling belittled after being accused of sitting in the wrong seat, and in recalling the event, she said, quote, "He knocked me." Sarah Mae also testified that she was victimized because I started out the front. Transcripts from 1956 also describe her trip to the hospital after the alleged assault. 2 witnesses on the bus that day took the stand and corroborated her story under oath. Before charging the jury, Judge Timmerman would make his biased feelings known.
He told the jury he disagreed with the Fourth Circuit. He told the jury that he believed the Fourth Circuit was wrong, but he was required to proceed and have this case go forward. So he let the jury know in no uncertain terms his personal views about the case.
He resented not only the case itself and our client, but he resented the lawyers. He resented us. And he treated us as so much garbage, you might say.
12 white male jurors decided the case in 30 minutes. The $25,000 in damages never came. Despite monumental change in national transportation laws and travel customs influenced by the federal courts, the South Carolina jury made sure that Sarah May never saw a dime.
Even though she got nothing in return, it stood for quite a principle. The decision was made. I didn't make the decision, but it was made generally by those controlling the litigation. Well, we've gone about as far as we can and should go in this case.
Archival images of social activism give us the reminders of incredible strides made toward improving oppressive conditions and erasing public hardships. Rewards trickle to some taking early risk, and that includes prestigious achievements to a few individuals lending a hand to Sarah May Fleming. Years after her NAACP legal team moved the case forward, the civil rights organization's best-known defense attorney, Thurgood Marshall, accepted a seat on the U.S. Supreme Court. Progress is also seen in Columbia, where the new federal courthouse now bears the name and likeness of another one of her attorneys who were seeking relief. Public honors now come to federal judge Matthew Perry. He feels the accolades for his former client are less than adequate.
I think that she should be recognized as having made a major contribution to the development of the law in South Carolina.
Columbia, South Carolina's downtown streets for decades have been familiar to civil rights protest. Example after example showcasing purpose and commitment. But during her 3-year fight in the city with a history for demonstrations, no one hit the streets to support Sarah May Fleming.
It's sort of sad that Sarah Fleming, who really did this on her own, and as far as she knew, lost, basically. You know, it didn't accomplish much for her in her life. It didn't change her life, really, in any way.
It wasn't until 2003, some 49 years later, that her battle finally found new light. Discovered by staffers at the state newspaper and reported by Lauren Marco, this piece filled in the missing gaps of time and an individual long forgotten.
Even her own children had little idea of what had transpired in 1954. That to unearth the headlines from the back room of my newspaper and to see that this woman paved the way for desegregation was astounding.
The recent headlines offered answers and enlightenment. Sarah May's siblings feel her contribution shouldn't be taken lightly.
I really think it should be talked about more, and even the younger people at this age, African-American people and white people, any race of people, they should see what happened back in that time, and thank God it doesn't change.
In her native Eastover, notoriety never came. When she died in 1993, Sarah May Fleming Brown was 59 years old. Well-wishers and admirers packed all the seats at Eastover's Goodwill Baptist Church as they paid their final respects. A published obituary listed her as a wife, mother of 3, and grandmother. Nowhere was there any mention of the historic case. This is her final resting place, just outside of the church. Ironically, she is surrounded by others who made unsung contributions. It is also a burial ground for former slaves.
I know that the headlines might look at Rosa Parks versus my grandmother, and at the same time, I want everyone to understand that this is not a discredit to Rosa Parks and her, commitment to the civil rights movement.
Rosa Parks was grateful for individuals like Sarah May Fleming and many others who never received any public attention. During a visit to Charlotte in the mid-1980s, sponsored by the Afro-American Cultural Center, Mrs. Parks made it a point to acknowledge the unsung, like her colleague in the civil rights struggle from South Carolina.
And I have to be very proud to think that it did take a lot of courage, not on the part of a few people, but of the many, many who've never been heard of and never will be mentioned in history.
She remained silent during much of her fight. Her words only appeared once in print and came after the 1956 Supreme Court decision. Sarah Mae told a reporter she was pleased with the conclusion reached by the justices, but went on to say that she would never again use public transportation.
Honestly, I think most people looked up to her because of her strong will. And I think most people didn't have the courage at that time to have the personality she had and to be the way that she was and to go in it, you know, without any doubt and just be strong. I think most people admire that about her.
While this case happened more than 50 years ago, getting over it for some may take a lifetime. The surviving children of Sarah Mae Fleming and the bus driver, Warren Christmas, chose not to be interviewed. Without question, this brave woman's fight broke new ground, opened doors for the first time, and brought equality in places where passengers could ride together. This was an important case to slip through the cracks, but one helping to lay the foundation during the early days of change across America. That's Before Rosa, Sarah Mae Fleming's unsung contribution. I'm Steve Krupp. Thanks so much for joining us.